Good
Good
morning,
morning, Joe.
Elaine. Oh, good morning, Elaine and Joe. Can you hear us okay?
Yeah,
Yes, I
little
can.
echoey.
That's okay. You won't be hearing from me very much, but we just want to make sure you guys sound good. I can hear both of you. Both look good. Just know we're already live streamed, so if you could just go back on mute and we'll get started at 10 o'clock.
Perfect. Thank you.
Thank
Thank
you.
you.
Okay, we have everybody in.
The District Court of Appeal of the State of Florida in and for the 4th District is now in session. Judge Robert Gross presiding. All persons having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning, everyone. Welcome to the November 18th, 2025 session, oral argument session of the 4th District Court of Appeal. We're handling this remotely today. So there's just a few rules, I guess, that we want to remember. First of all, there's a lot of attorneys, especially on the first case. So it's important that before you start your argument, that you identify yourself by stating your name for the record so we know with whom we're speaking. Secondly, if for some reason, and it hasn't happened yet, one of the judges drops off or suddenly you don't see them on the screen, please keep talking because this is being recorded and that judge will have the ability to review this, review the recording of this before we conference the case. Okay, with that being said, we have two cases set this morning. The first case is Herman et al. Versus Ewers et al. Is the appellant ready to proceed?
Yes, Your Honor.
Okay, please identify yourself and proceed.
May it please the court, Elaine Walter of Kula and Associates for appellants cross appellees Craig Cooper and Scott Herman. I'd like to reserve 5 minutes for rebuttal and to address the cross appeal.
Okay.
I'll just start. I'm assuming you're familiar with the facts because you always are. And I'm just going to jump right into the argument on the main appeal. The first issue we have is about an employment agreement and a survival clause in that employment agreement. It was subject to a motion for summary judgment. Therefore, the court standard of review is de novo on this issue. I'm going to start with the plain language of the agreement. The compensation of the employees, there were two agreements, one for Mr. Cooper, one for Mr. Herman. And it says, shall not take salary under this agreement. The compensation is outlined elsewhere in paragraph 5. And that compensation was profit share distributions based on 1/3 of monthly net operating profits generated under the agreement. Mr. Cooper and Mr. Herman were paid as double W-2 employees. That's in the record at 30/21. As were Lukens and Ewers. But then there's a survival clause. So the survival clause is that these payments to Mr. Herman and Mr. Cooper that they contracted for survived their employment with OxyLife, which was the corporation, no matter the reason for departure, whether it was termination, voluntary, involuntary, with or without cause.
So after the separation of the two plaintiffs, what happened to CNP? Did it continue under OxyLife's aegis? Did OxyLife assume 100% control of it?
So there's two dates that we probably need to look at. The short answer to your question, Judge Forrest, is yes. CNP did continue. Eventually, it was subsumed within OxyLife. But initially, in May of 2017, when the parties started to have some conflict, Mr. Cooper and Mr. Herman were locked out of everything, and OxyLife stopped paying them. Then they were officially terminated from OxyLife and CNP in November of 2017. So yes, your question, it is still operating. At this moment, I'm not sure, that's not in the record, but it did continue to operate.
Did the employment agreements include a non-compete and or non-solicitation clause?
They did, Your Honor. However, that was subject of a counterclaim that was dropped later on by the defendants / counterplaintiffs.
So was there anything under the way this case ended up, was there anything to prevent OxyLife from terminating them a week into their arrangement and taking over control of CMP and the plaintiffs then would not only not have any kind of survivor benefit, but would not be able to compete with the company that they had created.
So technically, yes, Your Honor, but there's also this survival clause that provides them, that's why this survival clause is there. It provides them the opportunity to reap wages, which is what the court determined below. And through this agreement, through the survival clause, they get them in perpetuity, and perpetuity here means their death or the death of the corporation. Does that answer your question?
Well, I guess that's their response. Their response was they covered themselves with the survivorship clause. What would well, we'll ask the defendants how they view that.
Okay.
Okay. So if we, so the trial court made mention of the rule against perpetuity, said this is like a rule against perpetuity's case. The initial brief spends pretty much most of its ammunition addressing this issue from the rule against perpetuity's vantage point. Is there an alternative argument? It's putting aside the rule against perpetuities?
Sure, Your Honor. I'm going to go a little back in the record. The trial court judge did say it seems like it would be prohibited by these wages, past employment, would be prohibited by the rule of perpetuities. His first order on the issue did mention the rule of perpetuities and set it out within the order. Then on rehearing, the judge backpedaled and said, I just don't think you can get wages if you're no longer an employee. There was absolutely no legal authority for that position or that ruling by the judge. There was nothing, no legal position argued by the defendants in this case to say that that is a premise of law, and the order contains nothing to show that it was substantiated by Florida law. So that is why our argument is grounded in the rule against perpetuities to show that there is no prohibition to this type of agreement. And that's because there are three reasons. One, the agreement vested immediately by its own terms with on page 172 of the agreement. And Florida courts define a vested right as an immediate fixed right of present or future enjoyment. And that's what these gentlemen had. And that's under City of Sanford versus McClelland. And that's a Florida Supreme Court case from 1935. Also, the rule against perpetuities, by its own terms, doesn't apply to profit sharing. That's subsection 5F of the rule. And Florida law itself does not apply the rule against perpetuities to contracts. There's longstanding law from the Florida Supreme Court from 1980 and 2008 that says on its face, the rule against perpetuities is a rule of property law and not of contract law. That is Old Port Cove, 986 Southern 2nd, 1279. And I'm going to butcher this name, Injahart versus Phillips, 383 Southern 2nd, 610.
Are there policy considerations against an agreement of this sort where employees are also shareholders?
Well, the trial court determined that we weren't shareholders. We're just employees. So not necessarily under the facts of this case and the rulings that happened, but there are some cases, one out of the 5th DCA, that upheld a commission agreement for an employee that was no longer working for the company. And that person was able, the contract provided for the payment of post-termination commissions. This is the same sort of agreement, different arena, but same sort of agreement. And that's Goodwin versus Blue Murray Insurance out of the 5th 939 Southern Second, 1098. We also have your case recently from last year, Judge Force, that you authored, that corporations themselves live into affinity, and the rule can't be applied to an entity the legislature permits to exist exempt from the rule. And that was Marshalls versus McWilliam. Any more questions on the first issue? If not, I'd like to move on to the second issue because my time is slowly creeping down.
You've got like 6 minutes, left, so you can use your time as you see fit.
All right. So the second issue that we have is a letter of intent or reorganization agreement. Again, the standard of review here is de novo because it is an order granting a judgment notwithstanding the verdict. The trial court found that there was absolutely no evidence in the record to support the jury's verdict of an award of $2.75 million to my clients as the half the value of the company OxyLife itself. There was an agreement that they would be entitled to be half owners if they met certain standards. But there is evidence of that valuation in the record, both by Mr. Cooper and by Mr. Ewers, who is one of the defendants. The revenue for OxyLife was between $3.5 and $7 million. The profit and loss statement noted total revenue of $4,184,000 and change. And the testimony from Mr. Cooper was that companies in the industry sell for 1 to 2 times revenue. What the jury did was enter a verdict for $2.75 million. That is less than half of $8 million if we double that $4 million. So the evidence was there to support that jury's verdict. The judge should not have acted as an uber juror and taken it away because the evidence was there, the inferences were there. And with that, I am going to leave the rest of my argument for my rebuttal time. Thank you.
Okay, very well, Ms. Walters. Thank you. What does the appellee have to say?
Thank you, Your Honor. Good morning. May it please the court. Joe Eagleton with Brannick Berman Insider for the appellees, Gary Ewers, Jerry Lukens, and OxyLife Respiratory Services, which, as Ms. Walter noted, does have a cross appeal that I hope I'll have a few minutes to address, although I fear my time will dwindle very quickly, just like Ms. Walters did. I do want to start with the first issue on the claim to payments into perpetuity. And I think we just heard a whole lot of argument that's nowhere in the initial brief in this case. So the initial brief challenges the application of the rule against perpetuities to bar these future royalty payments under the employment agreements. That's the issue in the issue statement in the initial brief. That's the argument that's in the argument section of the initial brief. That's what all the subheadings in the initial brief are talking about. That was not the basis for the trial court's decision. As the trial court made clear, and this is at page 12254 of the record, quote, "The court did not make a ruling that the rule against perpetuities was violated," end quote. So I think that resolves issue 1 of this case. They have only challenged the application of the rule against perpetuities, and the trial court said that was not the basis for my decision. So I think they've waived any other argument. I mean, these other arguments are interesting, but they are not in the initial brief in this appeal. The actual basis for the trial court's ruling was the fact that the plaintiffs were employees rather than owners. And the court says that explicitly at the same page of the record, quote, "What the court did rule is the plaintiffs were employees, wage owners, and any notion they could continue to be paid wages after they were terminated their employment is baseless." They have not appealed the ruling that the trial court made that the plaintiffs were employees, not owners. So again, I think that this issue is waived for appeal.
Well,
That
looking
issue,
excuse me, looking at the substance, putting that aside, and we'll obviously consider it, but putting it aside for now. So under the reading that the trial court gave the agreements, was it possible for them to sign this agreement, bring CNP into OxyLife, fire them shortly thereafter, and these guys, since they also have a non-compete, they pretty much lose their business, and don't see any more future earnings from that.
Well, I don't think they lose their business, Judge Force. They made a decision to enter into an agreement with OxyLife that made them employees of the company. They were not owners. That's a finding the trial court made in 2020 after an evidentiary hearing, again, that has not been appealed. And so, like any other employees, they're subject to the provisions of an employment agreement that they signed. So I think any employee is subject to potentially being terminated based on the terms of an employment agreement from their employer, and they would then be subject to whatever terms they have voluntarily, at arm's length, agreed to enter into an employment agreement that say. So, I
Well,
mean,
most employment agreements don't include a survivor clause like the one involved in this case.
well, I'm glad you raised that, Judge Force, because there's I think a very important point that I want to talk about on the merits, assuming the court's going to consider the merits of this survivor clause. And that is that in this industry, in this healthcare specific, highly regulated industry, payments to someone who is not an employee violate federal and state anti-kickback, patient brokering, Medicaid, ACA regulations. The plaintiffs admitted this, by the way, very early on in the case. This was a big issue early in the case before they changed lawyers and changed arguments. There was a whole fight about whether they were owners of the company or employees of the company. And the whole reason that mattered is because if they were not owners, excuse me, which is what the trial court found and what was never appealed and is not appealed today, then they have to be a current employee in order to receive payments or commissions from a company in this highly regulated industry. Their counsel at a hearing in 2019, this is page 12044 of the record, said, quote, in the medical industry, there is, when you are working for a company and getting distributions, you have to be a bona fide employee in order to avoid anti-kickback statute. Mr. Herman, one of the plaintiffs, filed an affidavit. This is at page 9705 of the record, where he said, quote, to comply with federal and Florida law, Mr. Cooper and I became full-time bona fide employees of OxyLife, and their expert. This is at page 6886 of the record. Back in 2020, when the whole fight was whether they were owners or employees, confirmed that in order to receive payments from OxyLife, the plaintiffs had to be, quote, bona fide employees of OxyLife. And it was not the intent of the parties to, quote, participate in any illegal patient brokering or kickback arrangement. So it may be the case that in other contexts, you could have a survivor clause that entitles you to payments after termination of employment. I don't know, but it is not the case here that this agreement could have authorized these plaintiffs to receive ongoing commissions. If it did that, then OxyLife would be in violation of a number of federal and state laws and regulations in this highly regulated industry.
Would a counter argument then be that the agreements were void ab initio, including the non-compete?
Perhaps, Your Honor. I don't know. The non-compete is not an issue that's here on appeal, so I confess that I hadn't really thought that through, but there is no claim currently that I'm aware of trying to hold these folks responsible for violating the non-compete.
Is it your understanding that the CNP continued after their termination?
Yes, that's my understanding from the record, Your Honor.
Okay.
So again, I see my time is starting to slip away from me, but I really just think that this issue is a non-starter because again, the initial brief only challenges the rule, the issue as to payments and perpetuity.
Let me interrupt. We understand that point. I understand that point. I mean, I'd like you to address the second point, in regarding, the judgment notwithstanding the verdict. Okay, I think you need to move on to that point, please.
Thank you, Your Honor. Yes. And I appreciate, that the judgment notwithstanding the verdict is a big deal. But I think what's a bigger deal here is sanctioning a $2.75 million damages award that doesn't have any support in the evidence. I mean, on their best day, they're cobbling together, like 3 sentences of testimony from a 1,300-page trial transcript here. There was no expert testimony on damages. They're basically citing 2 things now to try to uphold this verdict. One is Mr. Cooper's testimony, who's one of the plaintiffs here. His testimony was not valuation testimony. He testified about the company's revenue. He had no testimony about the company's liabilities, debts, loans, anything that would comprise a proper valuation. His only testimony was about revenue. He did say, this is one sentence, he said, quote, typically a DME company would sell for 2 times revenue. So I think, again, typically, I think is an important word there. It's very generic. That's not this company. That he's not an expert, by the way. His only knowledge is as to OxyLife, the company he worked for. And again, that's not a valuation of the business. It's not even pretending to conduct the kind of market-based valuation this court referred to in the Fidelity warranty case. And as Fidelity warranty, I think, also makes clear, that sort of testimony is speculative and cannot, sustain a company valuation number. It's not legally sufficient evidence of valuation. So that leaves Mr. Ewer's testimony, one of the defendants. So Mr. Ewers testified that he acquired the company for $3.5 million, and it was worth $3.5 million in 2016. Again, that's not a valuation. He actually spent pages of the transcript before he gave those answers saying repeatedly, I don't know, when the plaintiffs were trying to get him to say, what is the value of OxyLife as of the June 2017 breach date. So his actual valuation testimony here, to the extent there was anything, is I don't know. But even the $3.5 million number, what he acquired the company for is not a value of the company. I mean, you could acquire a company for $3.5 million. If you have a note to the bank for $3 million, the value is $500,000. And his testimony also was not as of the actual date of breach in this case. And so there's nothing here about the liabilities of the company, again, the debts of the company, market conditions. And what the record actually showed was the company was undergoing a lot of financial distress during the relevant time frame. And that's why these plaintiffs were brought in to try to help in the first place. There were real cash flow problems. And so the idea that the company was...
there are a lot of cases that stand for the proposition that an owner of property or a company is competent to testify to the value of the company, and what you point out would really go to the weight to be given to that testimony. In grand theft cases, we allow owners to testify, give their opinion as to the value of property and leave to the jury or the fact finder whether or not that is should be given a lot of weight. And isn't Mr. Ewer's testimony here competent, substantial evidence, which would, really, be a jury question?
I don't think so, Your Honor. No, because he didn't actually offer a valuation of the company. He answered a question as to what he acquired the company for. And he absolutely never answered a question as of what he thought the value of the company was as of the date of breach, which even the plaintiffs conceded was the appropriate time for establishing the damages.
Mr. Eagleton, didn't he also discuss that the company had made significant strides under the plaintiff's leadership, and that I believe as of when he was testifying, he believed the company would be worth no less than the $3.5 million that he had paid for it earlier? I agree with you that there was nothing about the value on the date of breach.
Yes, Your Honor, he did testify to that. But I think that the value as the date of the breach is important, because you could acquire a company for $3.5 million and it could be worth $3.5 million or more today. It could have been worth zero at a particular point in time, depending on the liabilities, the cash flow problems, loans that the company had, whatever might be going on with that company. And so the law requires the valuation here to be as of the date of the breach. The plaintiffs acknowledge that too.
But if the plaintiffs had helped increase the value of the company prior to their termination, isn't it common sense that the value wouldn't have been less than what he paid for it?
I'm not sure, Your Honor, because we're trying to parse like three lines of the testimony, I think. And so to me, I don't think any of this satisfies the legal standard for a business valuation under fidelity warranty. The court talked about in that case 3 ways that you can value a business. There's an asset-based approach, there's an income-based approach, there's a market-based approach. None of the evidence here satisfies any of those approaches that this court has said are legally sufficient to establish a business valuation in this type of case. And so
assume for the moment, hypothetically, that we disagree with you and we think that Mr. Ewer's testimony was sufficient to really justify revisiting this judgment, notwithstanding the verdict. Assuming that hypothetical to be true, what do you think the appropriate remedy we should impose in this case if we reverse it? What is the proper remedy?
Probably a new trial, I guess, on that count, Your Honor. I mean, there's certainly, the plaintiffs admitted that they were only entitled to 50% of the value of the company. So I still don't see how there's any records. I mean, I don't think there's any record support for any of this, as I've said, but assuming you're hypothetical, the valuation apparently that the jury had to have assigned here would have been $5.5 million. That's way above what even the plaintiffs argued in closing, in the rebuttal closing, would be the valuation. It's certainly well above, even if you assume the $3.5 million number from Mr. Ewers. So I don't see how there's really any evidence to support the jury's. I don't think there's any, but even under your hypothetical, I guess, Judge Gross.
I understand you disagree with that. Okay. All right.
I see I'm down to a minute, so unless there are any other questions on the JNOV, I'd like to just if I could spend a minute on the cross appeal. And the primary issue I wanted to highlight, and this was something that was raised in our side's motion for a new trial, was the methodology used by the plaintiff's CPA to calculate their damages. And by the way, I can't help but notice they had a very precise calculation on this count, down to the penny, for how much they thought, as opposed to what we were just talking about on the letter of intent. But their accountant used an accrual method rather than a cash basis method of accounting. And I'm not a CPA, but I think the difference is important in the sense that the contract here said the plaintiffs were to be paid based on sales, and sales, quote, shall be calculated from the cash received. So the formula was explicitly tied to cash flow, not to, a future forecasting of sales that could be included in an accrual accounting method. And we cited some cases on page 12 of the cross reply brief for the proposition that using a methodology not supported by the contract renders a damages award unreliable. And that error, I think, was really bolstered by some of the comments made by counsel that we've talked about in the cross reply brief, and the confusion the trial court recognized. And we've bulleted those. I see I'm out of time. We've bulleted those out on pages 7 to 10 of the cross reply brief. And so I would just ask the court to look at those and reverse for a new trial on count 1 as to the cross appeal.
Okay, thank you, Mr. Eagleton. Ms. Walter, you have the last say.
Thank you. I'm going to start with the main appeal, the reply to the main appeal, and just a couple of points. For the rule against perpetuities argument, clearly the trial court judge's analysis was bottomed on the rule against perpetuities, and that is why our analysis was so voluminous on the rule. Other than that, there was no basis stated. So the rule against perpetuities does not preclude what happened. People, you can contract for whatever you want, and there was very little argument about whether wages in perpetuity violate. Most of the argument below that Mr. Eagleton was talking about was whether you have to be an employee or you can own a company if you aren't part of a durable medical equipment company.
But,
so that's number one.
One of the things is that I understand, I understand that point. But I know you came into the case late and we're not on the brief. But I mean, do you agree with Mr. Eagleton's point that that if there's a point in reversal, it needs to be raised in the initial brief, and you can't rely on points raised in the reply brief to secure a reversal, and because they're waived?
I have to agree with that, Your Honor. That's black letter appellate law. But I do think that our brief sets forth a valid basis for reversal on this issue, our initial brief. As far as the second issue on the main appeal, Mr. Ewers did value this company in 2016. He said it was worth $3.5 million. That's at 758 of the record. And then he said it was more valuable in 2017, and that's the very next page. And as far as OxyLife's profit and loss statements that were in front of the jury, it said it was over $4 million in 2017. So if the jury was valuing this company to 1 to 2 times, 2 times is 8 million, and they gave up my clients 2.75. That is not beyond the scope of the testimony that was presented.
Your
As far
your opponent relied heavily on that fidelity warranty case, that we wrote. I mean, do you think that case is distinguishable from this case?
I do, Your Honor, and it's because there is some evidence here that shows the valuation of the company, the owners. We have an owner testifying to the valuation. We have an officer who clearly, if you read the record, is very familiar with the finances of this company. And this company is, he had 13-week forecasts. They had monthly reports. So I think that is part of the distinguishing factor from that case. I'm going to move.
A quick question.
Yes, Judge Forrest.
To the first issue, what about the arguments that the anti-kickback provisions would also prohibit this type of agreement?
They prohibit them from being owners for sure, but I'm not sure the issue of whether they could have wages in perpetuities or profits in perpetuity is as wages was addressed. And I'm sorry, I just don't have that information at the top of my head. So I would say that no, it's not necessarily a valid argument.
Okay.
I do want to get to the cross appeal, and I will focus on what Mr. Eagleton said. We have an expert who did an accrual basis, but trying to find my notes to make sure I'm in the right place. That's permitted under the rules. Like a evaluation doesn't have to be the valuation doesn't have to be precise. It needs to be close. There was also testimony by the expert that said the accrual method resulted in a lower figure than the cash basis method. So there's really no harm, no foul there. And again, damages don't need to be precise. And there was no Daubert challenge to Mr. Suckno throughout the record, and no real objection to him providing testimony. As far as the other issues on the cross appeal, I would assert that they're either waived or not preserved, or they just weren't error or anything by which this court should grant a new trial. The relief we're requesting is a reversal on the ruling on the employment agreement survival clause, limiting the damages, and a remand for trial on the remainder of the damages permitted under the agreement. Also, a reversal and remand for entry of a judgment consistent with the jury's verdict under the letter of intent or the reorganization agreement. And we'd like you to reaffirm the order denying the new trial in all respects.
Okay, Ms. Walter, thank you very much.
Thank you,
Folks,
Your Honor.
that was very well argued by the attorneys. Thank you very much for participating in oral argument today. Okay, we'll be in very brief recess for the second case. We'll bring the second case up and start that as soon as possible because we set them both for 10 o'clock. So we'll begin the second case very shortly. Okay, thank you, folks. We'll
Thank
be
you.
in recess, but only a short one.
Good morning, Erica. Can you hear us?
Yes, good morning. Can you hear me?
Great. Good morning. Yes, we can. And Marcus, can you hear us?
Yes, I can hear you.
Fantastic. Sorry for the delay, guys. I know they scheduled your case for 10, but they didn't specify that it would actually be 10:30. But
Oh, it's okay.
our other case just ended, and we're still live streaming now, so you can go ahead and mute yourselves, and we'll get started momentarily.
Okay, it looks like we have everybody here for the second case. Welcome, folks, to the November 18th, 2025 session of the Fourth District Court of Appeal. This is the second case that's set for argument this morning. I'm going to remind the attorneys, please announce your appearances for the record so we know with whom we're speaking. A lot of times there's shuffling that goes on at the public defender's office and the attorney general's office. So the lawyers doing the argument is not always the same as the person doing the brief. And remember, if for some reason one of the judges drops off, we're recording this session, and please keep talking as if the other judge is there, and the judge who dropped off will certainly have the ability to review the video of the session before we conference the case. Not that that's happened, but they tell me that it's possible, so we'll hear. So the case that we have now for argument is Carribo versus the state of Florida. Is the appellant ready to proceed?
Yes, Your Honor.
Okay, please introduce yourself and go ahead.
Good morning. May it please the court. My name is Erica Fulmer. I represent the appellant Jared Carribo. I would like to reserve 2 minutes for rebuttal, please. And I would like to
Go ahead.
I would like to focus on point 1 of the briefs. I am requesting that this court reverse and remand for a new trial because the trial court erred in telling the jury that appellant had nearly 30 prior convictions. This issue involves 2 different parts. First, was the door opened by the defense eliciting an exculpatory hearsay statement that would have opened the door to impeachment under section 90.806? And secondly, if it did, was the probative value outweighed by the risk of unfair prejudice? So basically, first of all, it was arguably not an exculpatory hearsay statement that would have opened the door under 90.806 because the statement in question was not being, his credibility as to that statement was not being disputed. The state was not, it was undisputed that he did not have jewelry on him. That was the statement that was being impeached with the prior record, that the detective stated he said he didn't have any jewelry on him. At that point, when that was elicited, the jury was already told that he was searched and that his clothes were collected and he didn't have any jewelry on him. So, and that's
Quick question. Wouldn't that be probative though to the charge of theft, that it bolsters his argument that he didn't take anything?
it could be relevant to that, but it also, the question itself isn't, did you take any jewelry? Are you in possession of someone else's property? It just is, do you have any jewelry on you? So arguably, it has nothing to do with whether he had any stolen jewelry. So it didn't go to the elements of that offense. But even if you disagree with me that, the door was opened under 90.806, I think the bigger issue is that under 403, that the probative value of the statement was far outweighed by the risk to unfair prejudice, because the probative value was pretty much non-existent because the jury already knew he didn't have jewelry on him. And the prejudicial effect of the jury hearing that he had such an extensive criminal history was extreme, because one of the issues in the case, or the only disputed issue really, was whether this was a burglary or a trespass. He was conceding that he was in the house, and the only issue was, did he enter the house with the intent to commit a crime therein? And
Let me ask, is there any import to the fact that the state didn't object when the hearsay was first brought in? When they made the hearsay statement, state didn't say anything, and then a little later they said, "Oh, you opened the door."
Right. It is important because although the state isn't required to object, they can allow, the defense to make mistakes and let in things and capitalize it. They're allowed to do that. But it is important that the fact that the state didn't object to it shows that they didn't believe that he was lying about it. So if they didn't think it was objectionable, then you would think they would also believe that it wasn't something they needed to impeach.
Would you address
Fulmer.
the fact that in the bench conference that was had shortly after the statement was made, Ms. Nemirovsky said that she wasn't necessarily introducing the statement for the truth of the matter asserted. She offered it to show his demeanor, but yet she had asked at my count, no less than 8 or 9 questions prior to that question that all established his demeanor, his cooperation, and etc.
And she did say that. That one's a little tricky because she did say in this question itself, did he seem surprised? Did he, you know, when you asked him that? So it may have been an accident that she blurted out. I'm not sure, but it doesn't really change the fact that it came in. So it, you know, it was elicited. I can't get around that. I
And
mean,
how is
I
it
don't,
anything other than exculpatory, self-serving hearsay?
right. It, right. I mean, I don't know if I want to raise that it was not for the truth of the matter asserted. I'm not going to raise that argument. So yes, I mean, it does appear to be exculpatory in the sense that it's self-serving, but that doesn't automatically open the door under 806. The statute says the credibility of the defendant may be attacked, and if attacked, it may be supported, you know, you can impeach it. But
And
if
isn't it that
it's,
if not for the theft of the jewelry, it wouldn't be a burglary? If he was
well,
just in there, as the defense asserted, looking for a friend and then suddenly realized I'm in the wrong house,
mhm.
if not for
Right.
the theft of the jewelry, it wouldn't be a burglary, correct?
Well, there's other crimes someone could commit. The way
A
that
trespass.
right, the information didn't charge the burglary just for the theft. It's just to commit a crime therein. So they could have thought maybe he was trying to steal something else.
But they're not
So,
required to allege a specific crime, correct?
right, they're not required to, but I'm saying that, you know, the jury acquitted him of that theft, but perhaps they could have believed he was there to commit some other crime or maybe steal something else, or maybe the state just didn't prove the theft, but maybe the fact that they heard that he had nearly 30 prior felonies weighed in their mind when they were deciding whether he entered the house to commit a crime, whatever it may be, in the house. Because now they
Right.
know.
Where
It
did
was
the theory,
23, sorry.
sorry, just a quick question. Where did the theory that he was in the house looking for a friend, where did that originate?
Well, that was based on testimony that there was a pond across the street and people would shoot, hit golf balls and fish across the street. And um, I, and they made the argument that he knew people in the area, or I'm sorry, no, that wasn't just based on that. And that was the argument, the theory of defense. They weren't required to present, you know, they didn't have a burden to prove anything, but that was their theory, that the state couldn't prove that he was there with the intent to commit a crime therein, that he could have been there to surprise a friend. And that went to the only issue in dispute.
But he didn't take the stand and introduce that. There was no, or nor did that come in from the police and any admission that he made, right? I mean, that was just some theory that they floated in closing argument, right?
Right, exactly. And if they had introduced a statement like that, that may have opened the door, but the statement,
Clearly would have opened.
yeah, the only statement that came in was, I don't have jewelry on me. And that's the limited thing that his credibility was being assessed. You have
And
to
would
look
you,
at.
would you address what significance, if any, there is in the number of times that Ms. Nemirovsky argued in closing that they never found any jewelry on him, coupled with you can't prove a burglary? Those two things in conjunction.
I'm sorry, can you repeat the question? I
Sure.
didn't quite under-
She said a number of times in her closing argument, kept repeating that he didn't have any jewelry on him. There was no jewelry on him. They didn't find any jewelry on him, and tied that in almost the same sentence with, therefore, you can't prove a burglary. And isn't his statement that she elicited, doesn't it go directly to that?
Does go directly to that, but there was also other evidence to establish what her argument, that he didn't have jewelry on him. So she wasn't relying solely on that hearsay statement. But yeah, she did argue that because they didn't prove the theft, that they didn't prove a burglary, but the state also didn't prove any other offense as well. So that was the only crime therein that they were specifically charged charging him with. But that doesn't mean his intent. One of the elements of burglary is the intent to commit a crime therein. That's not one of the elements of the completed theft charge that they acquitted him of. So I just realized I ran out of time, but I would ask this court to reverse and remand for a new trial. Thank you.
Okay. Thank you, Ms. Fulmer. Okay. The state, what does the state have to say?
May it please the court, Marcus Kelly, Assistant Attorney General, on behalf of the appellee, the state of Florida. The state would, just to continue on that aspect, the state would argue that he was interrupted. The alarm went off and he immediately ran out of the house on that aspect. With regards to the statement itself, the state contends that it was a material exculpatory hearsay statement that directly went to his culpability in this case. He did not have any jewelry on him. Ultimately, the jury did.
Well, but isn't that an undisputed fact? I mean, you know, the police officer had already testified that he had no jewelry on him. So I mean, it doesn't relate. It's just a fact that's undisputed in the case.
Precisely, Your Honor. A fact in and of itself is just that. But when the declarant adds his credibility to that fact, it gives it a weight that the jury must be able to weigh against. And that's what.
So you're saying that him saying that he didn't have anything on him gets more weight, or would get more weight, than the police officer saying, hey, we searched the guy up and down and he didn't have any jewelry on him.
I believe it reinforces the fact that he didn't commit the theft crime. I mean, let's talk about the what. So the what is it, 30 felony convictions that were introduced into evidence. So they went to impeach what statement is that being impeached? That because it's his credibility was that he said I don't have any jewelry on me. So that's undisputed. So usually we have a very broad admission in these things that allows impeachment by prior convictions. So well, Your Honor,
the nature of the impeachment seems like that you're saying you're not calling him a liar for saying he didn't have any jewelry on him, are you? I mean, so it seems to me that there's minimal impeachment weight that can be ascribed to those 30 convictions, because you don't disagree that he didn't have the jewelry on him. You know, I mean, you're not trying to show him to be a liar as to that fact.
Well, Your Honor, it's also going to his demeanor to try to assert a way that he wasn't committing a burglary or a theft.
Well, if it goes to his demeanor, in other words, let's talk about that. You know, I think it could go to his demeanor. The lawyer argued at page 449 of the record that it wasn't necessarily for the truth of the matter asserted, but it shows his demeanor and other things. Well, if it shows his demeanor, then it's not being offered for the truth of its contents, and then it's not hearsay, and then the section 90.806 doesn't come into play.
Yes, Your Honor, but that is also the thing, is that his statement, the rule requires that once the fact finder hears a hearsay statement, then it's permitted to impeach them under 806. But
it's not. But if it's offered not for the truth of its contents, the truth of its contents is I didn't have any jewelry on me. If it's not offered for the truth of its contents, but to show that he was cooperative with the police or his demeanor, if it's not offered for the truth, which it couldn't be in this case because it's agreeing with the police statement, then it's not hearsay, isn't it? It's a non-hearsay case. It's a non-hearsay statement, and a non-hearsay statement is not subject to impeachment, right?
That is correct, Your Honor, that legal assertion, but we believe that in this case, his statement is a hearsay statement, material and exculpatory, and it went to his culpability in this case.
Well, explain to me, hearsay is an out-of-court statement that's offered to prove the truth of the matter asserted. So in this case, the hearsay statement was, let's say, just to make it easy, I didn't have any jewelry on me. So that's the statement that we're looking at. If it's not offered to prove that, if it's offered to prove his demeanor or his cooperative with the police, then it's not hearsay. And if it's not hearsay, isn't it true that section 90.806 doesn't apply?
Yes, Your Honor. But the fact that he was charged with having jewelry on him, he was having taken jewelry, and he said, I did not have any on me when he was in custody, that goes to his credibility.
Let me ask. Okay, so this theory that gets floated out of the blue that he's there to look for a friend without any argument supporting it other than this golf glove and people that drive balls into the pond or something like that. Um, is is that any kind of theory at all supported by anything at all other than just throwing something out?
No, Your Honor, there was no evidence to that. And in fact, there was evidence elicited that it was a new construction home and she was the first homeowner of that home.
So if you have nothing in terms, you have the state seemingly making a solid argument for burglary. He's in a place where he's not wanted, or where he has no right to be. Doesn't have the permission of the owner. There's no explanation as to why went through the back door of a homeowner's house. She's the only owner that's ever lived there. No support for anything else. So even if there was error, is this harmless error, or is this? I don't recall the state really making a big show of harmless error in their answer brief.
We did raise a DeGaio argument at the very end, Your Honor. It is harmless. I mean, his shoe print, I mean, he admits to being in the house. So the question is ultimately upon the jury to determine what he was doing there. And what we have him on video, we have his shoe print in the residence. We have the testimony that there was a jewelry box that is disturbed. And also, I think it's a very important fact that when the alarm went off, he ran out of the house immediately. So this was essentially an interrupted act.
And on I guess the same question I asked the defense counsel. Is there any import to the fact that they didn't raise an objection when the hearsay was brought in?
Well, Your Honor, as the appellant conceded, that there is no requirement for the state to lodge an objection to preserve this issue or to raise an issue.
Although doesn't it sort of make an argument that it apparently wasn't that material because they didn't even object when it was brought up?
I can't speak for the mindset of the prosecutor at that time, Your Honor.
Mr. Kelly, I note that in the answer brief, the state did not, unless I missed it, did not rely on Mathis. But aren't the facts in this case a little more, I want to say, egregious than in Mathis when on cross, when the defense attorney asked the officer on the stand and said, and during the conversation you had with my client, he never made any admissions to you. The officer answered, that's correct. And that was sufficient to allow the introduction of the number of convictions. In Mathis, the trial judge did it wrong and actually admitted the convictions themselves. So the second reversed for that reason, but also held that it would have been proper to tell the jury the number of convictions. And the only statement that was introduced was, that's correct.
Well, yes, Your Honor. And that's the thing, is the defense was going through the cross-examination of the officer and then posed the question, was there anything else you did? And then he said, I asked him, and they could have stopped there. That would have been the opportunity to not open the door in this case. But they continued by adding a demeanor, but also his hearsay statement at the same time when they elicited it in a combination.
And how do you address the argument that the question really was designed to, as Ms. Nemirovsky said, not necessarily offer it for the truth, but for his demeanor? How are we to look at that?
I think it was offered for both, Your Honor. It was how his hearsay statement, how he presented his hearsay statement, which ought to be a factual assertion, but also the manner in which he delivered that.
And it was 23 felony convictions and 5 crimes, misdemeanors involving dishonesty?
Correct, Your Honor. And 403 is designed to prevent unfair prejudice to the defendant. We didn't get into the nature of those crimes, but his criminal history should not be, 403 does not prevent his criminal history from coming out. Obviously, his criminal history is prejudicial, but that's not the kind of prejudice that 403 is designed to prevent.
And so is there anything you want to add to that, given Mr. Karibo's argument that it was really the 403 balancing that was the problem?
No, Your Honor, and just I would again reassert that it was the number of convictions, felony convictions, crimes of dishonesty, a powerful curative instruction was given at the same time, and ultimately the jury did acquit him, so it didn't hold that against him at the same time. He was acquitted of the very essence of what that statement went to.
Well, but again, I mean, the nature of the statement was, I didn't have anything on me. This is an offer to impeach the underlying statement that a defendant makes. And, it seems to me that that's fairly slight. I mean, we certainly, like, if we're talking about 28 felony or criminal convictions that are used for impeachment, that's a pretty powerful, amount of convictions. Do you think that even harmless error could even come into the play? We could write an opinion to say the erroneous admission of 28 felony convictions is harmless error in this case?
Your Honor, assuming arguendo that it was an error, I would say that in the evidence that he was acquitted of at least one of the crimes goes to show that it was not that prejudicial to the jury. Okay. And also in light of the evidence against him.
Okay. Okay, thank you, Mr. Kelly. Do we have any brief rebuttal from Ms. Fulmer?
Yes, if I could have maybe 1 minute, that would be great.
Okay, 1 minute.
Thank you. Just to sum it up, the state wasn't saying that appellant was lying about having no jewelry on him. They basically wanted the jury to hear that he has an extensive criminal record to show that he entered the house with the intent to commit a crime therein because he's a bad guy who has a propensity to commit crimes. It's not harmless because that's the whole reason the felony petty theft was bifurcated to keep out his prior thefts. The reason for that is to protect the presumption of innocence. So it's a huge error to allow the jury to hear about someone's prior felonies, criminal record, and it just goes to propensity. There's just the risk that they'll view it that way. So I just wanted to end with saying if we request that you reverse and remand for a new trial. Thank you.
Okay, thank you, Ms. Fulmer. Okay, that concludes our calendar for today, which is, I always have to check my watch, which is November 18th, 2025. And we will be in recess till the next scheduled oral argument, which I think will be on Thursday. So thank you very much for attending, folks.